Hello, everyone, and welcome to Brooks Kushman's webinar today. During today's discussion, we'll be discussing the 2019 IP litigation developments that have had a material impact on the practice of IP law. We'll try to preview some of the issues that the Supreme Court and the Federal Circuit will likely take up in 2020. Today, you'll be hearing presentations from myself, John Leroy, as well as my colleagues, Chris Smith and Rebecca Canner. If you have any questions about the presentations today, our emails are provided at the beginning of the presentation, also at the end, and we're happy to hear from you and provide you some feedback after the webinar. In the days following the presentation, we'll make available a recording of this webinar as well as the content, which there's a lot of to cover today, because 2019 was a big year in terms of IP developments in the federal courts. So let's get started. We'll begin each presentation with a brief introduction of the speaker. I'm going to go first. I'm a shareholder at BK. I've been here for over 20 years now. I have a master's degree in electrical engineering, and like most IP lawyers, started in patent prosecution. But for about the last 15 years, I've focused predominantly on electrical and software litigation, and also focusing on trade secrets and copyrights, mostly in the software space. But I co-chair the firm's SEP and FRAND, the Standard Essential Patent aspect of our practice. And that is where we're going to start today. We're going to start with the TCL v. Erickson case. And when it comes to the Standard Essential Patent and FRAND issue, that's something that I've personally been in the middle of for about a decade now, mostly representing adopters of the technology, and generally in the automotive industry, of embedded cellular and Wi-Fi technology. At one time or another, I've personally dealt with almost all of the individual SEP owners, as well as the pools, Avanci, Via, and Sysvel, and others. I've probably seen almost every form of license offer, claim chart. I've either made or heard almost all the arguments that have been made by the licensors and the licensees. And needless to say, disputes remain. Disputes remain in terms of how to truly determine a FRAND rate. So when we turn to the TCL v. Erickson case, Erickson is one of four long, thorough district court decisions that have wrestled with the SEP FRAND issues. Judge Selna in this case, like Judge Robarts in 2013, and also Judge Holderman and others, have invested countless hours attempting to define a reliable methodology, at least in the courtroom, for estimating FRAND rates. I viewed this particular appeal as a great opportunity for clarity because the other decisions hadn't reached the Federal Circuit appeal level, and we didn't get the clarity in those cases that I was hoping we would get from the TCL case. This was an opportunity for the Federal Circuit to provide some reasoned guidance, out of the court that defines patent damages law in the first place for the rest of us. But as soon as the hearing before the Federal Circuit, it became quite clear that the court may not be willing, at least not at this time, to provide the clarity that us in the trenches, whether licensors, licensees, or litigators, desperately need. So let's jump in. The parties. TCL makes handsets. They're manufactured in China, but they're distributed worldwide. TCL, while may not be every household name, is the fourth largest manufacturer of handsets, at least in the United States. Erickson, on the other hand, holds a large portfolio of so-called standard essential patents in all of the predominant standards, 2G, 3G, and 4G LTE. Erickson, as a member of the standards bodies that promulgate the 2G through 4G standards, has a commitment that it's going to license all adopters of the standard technology on fair, reasonable, and non-discriminatory terms. That's where the FRAND acronym comes from, for those of you that are less familiar. The standards body is ETSI. It's the European Telecommunications Standards Institute. It defines the standards. It defines this obligation to license on FRAND terms, but it does not define what FRAND is. It does not make determinations as to whether a patent is or is not standard essential. So they've essentially created a problem for the rest of us to deal with. In this case is no exception. TCL is and always was willing to license Ericsson's standard essential patent on FRAND terms. Legally speaking, TCL is the third-party beneficiary of Ericsson's FRAND commitment to ETSI, and is entitled to a license from Ericsson on FRAND terms. The parties, like many in this space, spent years on successfully negotiating license terms, and broad litigation ensued in both directions. The next slide, we have a timeline, and I'm not going to go through this in great detail in the interest of time, but the important point is that in 2007, the parties actually succeeded in securing a license agreement. It was had a 7-year fuse, and you'll see that in 2014, when that fuse expired, litigation ensued. Over the years, like many people in this space, what was once 2G became 3G and 4G, which is basically where we are today and what this litigation focused on. But throughout the licensing discussions in 2012, Ericsson decided to add some incentive for TCL to take a license. Ericsson sued TCL in 11 different lawsuits in 6 different countries all around the world, but not in the United States. And that's common. We're seeing this right now in the automotive industry, where there are a multitude of litigations pending in Germany right now between Nokia and Daimler. But in 2014, TCL sued Ericsson in the Central District of California. That's the case that gave rise to the Federal Circuit's appeal that we're going to talk about today. There, TCL asserted that Ericsson's licensing offers to that point in the negotiations were not FRAND. TCL seeks a judicial determination as to what the FRAND rate actually is. TCL, of course, asserted some patents of its own. Ericsson turned right around and sued TCL in Eastern Texas and Eastern District of Texas. Those cases were consolidated into the California case before Judge Selna, and remarkably, the parties were able to stipulate to a worldwide anti-suit injunction. The litigations against one another stopped, but for this case before Judge Selna. In 2017, Judge Selna issued a 115-page single-space decision doing his best to determine what a FRAND rate is and an appropriate remedy in that case. And that, of course, is the focus of the appeal that gave rise to the Federal Circuit's decision. To understand some of the issues that we had hoped the Federal Circuit would get its arms around, we have to understand the decision. Now, it's very difficult to summarize 115 pages in a few slides, but I want to just get a few highlights. And the threshold issue was Judge Selna's recognition that certainty is a doomed undertaking, it's complicated, and that his decision would be subject to criticism. But he nonetheless tried to get through the day and do the best he could. On the litigable issues, he found that Ericsson's license offers to that point were not FRAND, but nonetheless, Ericsson had played nice and had not breached its FRAND commitment to Etsy. Different courts approach that issue differently. Some courts require you to be FRAND before you get to the courthouse. Other courts, such as in Germany, allow you to become FRAND at some point during the litigation before it's over. Judge Selna took sort of a middle ground, and ultimately TCL's breach of contract claim was jettisoned. Judge Selna rejected both parties' very complex but contrary approaches to determining FRAND rates. They both had fantastic experts with thorough calculations, and the judge rejected both of them. The judge took his own approach, but it was a carryover or a variation of what TCL had proposed, something called a top-down approach. We'll talk more about that. But at the bottom of slide 7 here, we have a chart that at the end of the day, whether it was a coincidence or baby splitting and working backwards, the court ended up almost right in the middle of what TCL was proposing as a FRAND rate and what Ericsson was demanding. We have some percentages here. These are percentages that would be applied to the net price of a handset, a cellular telephone, and this is just for the 4G standard. Judge Selna's opinions is full of charts and rates, applied in a lot of different ways on a worldwide scale, but this just gives you a summary of where he ended vis-a-vis the party's original proposals. Judge Selna's top-down approach, what it does is it starts with a threshold question. What's the total that any adopter, whether you're making a cell phone or an embedded module for an automobile, what's the most you as a manufacturer would want to pay for the privilege of having 4G connectivity, for example? Once you know that, then you multiply it by each patent owner's sort of relative slice of the pie. And to put this in perspective, the 4G standard alone, which all of your telephones in your pockets use, have over 92,000 patents declared standard essential. That's over 6,000 patent families just for 4G alone. And then the question, of course, is what percentage of that is owned by Ericsson? So once you know the total amount someone would be willing to pay for the whole kit and caboodle, and you know Ericsson's sort of piece of the pie, you can multiply those together and determine Ericsson's effective royalty rate. That's the top-down approach. TCL, it's much more complicated than I just described, and that's what most of this decision is about, which we won't go into great detail, but TCL presented a 9-step approach. Ericsson did not present any top-down approach, and instead relied entirely on prior licenses. And as indicated earlier, the court modified what TCL had presented and made some modifications. One of the important ones was he treated all patents as having equal weight, something a lot of people take issue with. He excluded expired patents. And he picked 5% and 6% as the total aggregate royalty for 2G/3G and 4G. And that was largely based on parties' public statements coming into the litigation. Slides 9 and 10, I'm not going to go into them in great detail, but the point is that Judge Selna tackled all kinds of very difficult issues that we as licensors, licensees, and litigators deal with in terms of which law applies and what agreements are we going to use. Slide 10, when it comes to comparable licenses, these are very complicated agreements. They involve, in some cases, hundreds of patents going in opposite directions. Some are standard essential, some are not standard essential. Some relate to the products that are issued, some don't. And to use those licenses, you have to invest a tremendous amount of time in calling balls and strikes. And we were certainly hoping for some clarity from the Federal Circuit as to, which of these approaches and decisions he made were acceptable and which were not. At the end of the case, as I indicated, this was a bench trial. Judge Selna had determined that there were no legal damages issues, and he issued a remedy once he had made his rate determinations, which we have here in Figure 17. He issued his determination in the form of an injunction. It's an injunction setting the rates TCL must pay going forward. The second bullet is the lump sum amount, $16.5 million, the TCL must pay for the past, and he ordered dismissal of the competing claims for patent infringement and associated invalidity and non-infringement claims because they were moot in view of this license he had just entered by injunction. We're going to skip slide 12 in the interest of time, but at the end of the day, Judge Selna decided, despite the parties' initial stipulation that there would be no legal issues tried to a jury, Ericsson had objected and raised this issue numerous times, and in the court's post-trial final ruling, did not address Ericsson's demand for a jury trial. So Ericsson appealed to the Federal Circuit. It made 3 predominant arguments. The first one is the loss of its jury trial opportunity, which are traditionally available, obviously, we all know, in patent infringement cases and anticipatory declaratory judgment actions. Specifically, at the very least, the lump sum compensation for the past unlicensed sales that Judge Selna set, Ericsson believed it was entitled to a jury trial on that. The second and third arguments are the more substantive arguments that we were really hoping the Federal Circuit would take up, in addition to the procedural argument, the threshold jury trial argument, specifically Judge Selna's decision that all patents are treated equal. We know that's generally not the case. That's kind of the antithesis of the footprint of the invention law in the United States. The law the Federal Circuit has promulgated requiring apportionment specifically to avoid overcompensating patent owners for unclaimed subject matter. Ericsson also took issue with the fact that the ratio of Ericsson's slice of pie calculation, the numerator which Ericsson had defined was, in their view, thoughtful, had involved claim charts and thorough analysis, whereas the denominator that the court had used went through hundreds of patents, cursorily, some cases spending only 10 minutes per patent, and admissions that the entire patents in many cases were not even read. So you have a a relatively small numerator and a very large, unreliable denominator that made it appear, at least from Ericsson's perspective, that its piece of pie was smaller than it should have been. They took issue with that. And as indicated in the third bullet, they, like any other litigant, thinks that the judge failed to include certain comparable licenses and then included other licenses that were, in the litigant's view, uncomparable. Unfortunately, the Federal Circuit didn't get past the first issue. I mean, that was an important issue, and that provides some guidance for us. And the Federal Circuit's decision is not that shocking. When the court ordered, $16.5 million in payment for past infringement, it was no real stretch of the imagination that that was, in fact, a legal claim for damages. It was not specific performance. It was not restitution. Just because it was entered through an injunction does not make it equitable. So that wasn't that revolutionary. What was frustrating is what happened next. The Federal Circuit made no mention of all the other issues raised on appeal, but had no problem vacating and remanding not just the past payment, but because there were common issues to both the past and prospective royalty calculation as Judge Selna presented them, they vacated both. So we're back to ground zero. And the jury now is to make these determinations with virtually no guidance on any of the work that Judge Selna had done or the objections that Ericsson had made. And, so I anticipate there will be some form of a jury trial. It will definitely be appealed, and in a year or so, we will be talking about this case again. All right. That concludes the TCL v. Ericsson, and now I'm going to pass the baton to my colleague, Rebecca Cantor.
As John said, my name is Rebecca Cantor. To give you a bit of background about me, I'm also a shareholder here at Brooks Kushman. I have been with BK for about 8 years, and before that I worked at Benson & Elkins in New York for 4 years. My background is in chemical and pharmaceutical engineering, and I started my career while I was in New York doing Hatch-Waxman litigation. Since I've been back in Michigan, I've done really patent litigation in all technologies, also trademark litigation, and opposition and cancellation proceedings in front of the Trademark Trial and Appeal Board. And in addition to, my work here, I also teach patent litigation at the University of Michigan Law School. So I'm going to turn to a case that is currently in front of the Supreme Court about genericness. And really what it's about is so-called generic.com trademarks, meaning a generic word followed by a top-level domain. And this all started when Booking.com filed 4 trademark applications in 2011 and 2012. Now, I'm sure most of you, if not all of you, are familiar with Booking.com. It's a very popular website. They claim that they are probably the most used website for making hotel reservations. Haven't done any independent research, but that's what they claim. And they've been using the Booking.com website since 2006. In 2011 and 2012, which was after 5 years of use, they filed 4 trademark applications in Class 43, and all of them included services related to making hotel reservations. The USPTO declined registration on 2 alternative bases for each of these. The first was that the mark as a whole was generic. The idea was the word booking is a generic term for making hotel reservations, or just making reservations in general. And the simple addition of a top-level domain like .com to the end does not change the fact that booking is still a generic term for the services being offered. The examining attorney also said even if Booking.com isn't generic and it's descriptive, there wasn't enough evidence of acquired distinctiveness to allow Booking.com to register under Section 2F. I should mention that some of these marks were stylized, and the examining attorney did think that the stylization was enough for trademark protection if the words Booking.com were disclaimed. But Booking.com was not willing to disclaim those words. So instead, they appealed to the Trademark Trial and Appeal Board. The Trademark Trial and Appeal Board affirmed these rejections based on the exact same reasoning. And this isn't exactly a surprising decision. The TMEP basically says that in almost all circumstances, a generic .com will be considered a generic mark. It leaves open the possibility that there could be extenuating circumstances in which that wouldn't be the case, but the general rule is a generic .com is most likely generic. The Federal Circuit agrees, and we'll get into this a bit more later, but in each case where the Federal Circuit has considered the registrability of a generic .com mark, it has found the mark to be unregistrable as generic. So what did Booking.com do? Well, they knew that if they went to the Federal Circuit, they were going to lose. So they decided instead to appeal to the Eastern District of Virginia. Now, for the first time, when they were in the district court, Booking.com presented new evidence of acquired distinctiveness in the form of a Teflon survey. For people who aren't familiar with Teflon surveys, they're surveys that are specifically designed for showing whether the primary significance of a word is a brand or a product, or in this case, a service. And they actually started with the mark for Teflon, hence the name. So when Teflon first came out, it was a specific product, nonstick surface for cookware. And there was a case, and the question came up, well, is Teflon now considered a generic term for nonstick surfaces, or does it still indicate the particular source of those nonstick surfaces? And the way Teflon surveys work is you ask the survey participants whether they consider a word to be a brand or a product, or in this case, a brand or a service. And in this case, what happened in this Teflon survey was that 74.8% of consumers recognized Booking.com as a brand. But I want to talk about that a little bit more because I think those results are a little bit misleading. There were several terms in this Teflon survey, but three of particular note. One was washingmachine.com. That's a completely fake, made-up brand. There might be a website at washingmachine.com, but there's not, as far as I know, a company called washingmachine.com. They also had supermarket, which is, of course, a generic term, and sporting goods, again, a generic term. What they found was for the two clearly generic terms, nearly 100% of the participants correctly identified them as referring to a product and not a brand. But when we have washingmachine.com, just by adding the .com, 33% of participants believe that to refer to a specific product or a specific service. That's quite a bit of noise in the survey, and it really makes you question, of these 74.8% of consumers who recognized Booking.com, how many of them recognized it because it had .com at the end, and people are aware that when you have a domain, only one company can exist at that domain. So this is kind of a long way of saying that a Teflon survey is probably not extremely appropriate in this case. The other problem with a Teflon survey here is that Booking.com has spent a lot of money in advertising. They spent the kind of money that you would need to prove acquired distinctiveness. So people know that Booking.com is a brand because they've seen ads for it, they may have used it. Well, when you're looking at that type of evidence, that's really more acquired distinctiveness evidence, and not genericness evidence. So there is probably some conflation between acquired distinctiveness and genericness here. And that's just legally not helpful because once a term is generic, like booking, there's no dispute that booking is a generic term. It can never become not generic. Booking is always generic. Any generic term is always generic. No matter how much that term becomes associated with one company, it will still always be generic. So it's really unclear whether this Teflon survey was just finding evidence of acquired distinctiveness or whether it was finding evidence that Booking.com was not generic. In any event, the district court found this Teflon survey very compelling, and it reversed the PTAB at the summary judgment phase. And basically what the district court said is, while booking might be generic for hotel reservations, by adding .com to the end and considering the mark as a whole, it's descriptive. And as I said, the district court gave a lot of weight to this Teflon survey, as well as other evidence as well as really other acquired distinctiveness evidence, such as how much Booking.com had spent on advertising, how many customers they had, their share of the marketplace, and things like that. just one note, the district court also awarded $75,000 in fees to the patent office. That part kind of went away. That was before the Supreme Court's decision in the Peter case, but that was something else that was in there. Okay, so then the patent office appealed to the Fourth Circuit, which affirmed, based on much of the same reasoning that was in the Eastern District of Virginia opinion. And this is where I say as you can see, the only issue here was, does adding a TLD to a generic term make that mark descriptive? Because in this particular case, as I've mentioned, Booking.com had a lot of evidence of acquired distinctiveness. So if Booking.com was descriptive, there was really no question that it was registrable. But if Booking.com was generic, then it wouldn't be registrable. And again, the Fourth Circuit gave a lot of weight to this Teflon survey. And the court discounted evidence that there were other URLs that contained Booking.com, such as hotelbooking.com. So the Fourth Circuit's decision really created a circuit split here. As I mentioned, the Federal Circuit has repeatedly held that generic.com marks are not registrable. They're generic. That was true for hotels.com, lawyers.com, mattress.com. The Ninth Circuit has followed the Federal Circuit's lead and found that advertising.com was generic for advertising services. And in fact, going back to the Fourth Circuit decision, there was one judge who dissented, and he actually said that the majority opinion conflicted with the determination that every other court has reached on this issue. So, in light of this circuit split, the Supreme Court granted cert, and oral arguments are currently scheduled for March 23rd. The USPTO has already filed its brief. Booking.com has not, but I was able to look at their basically opposition to the petition for cert. The question the Supreme Court specifically is going to answer is whether the addition by an online business of a generic top-level domain, such as .com, to an otherwise generic term can create a protectable trademark. The Patent Office is basically arguing that the addition of a TLD to a generic term is no different than adding a corporate identifier, such as company or limited or incorporated, to a generic term. And in the late 1800s, the Supreme Court held that simply adding company to the end of a generic term was not sufficient to make that term trademark protectable. The USPTO also noted, as I mentioned before, that no matter how much success a generic term has had, you can never take a generic term out of the public domain for the services that it has become generic for, goods or services it has become generic for. And that what the Fourth Circuit did, in its opinion, was really extend the doctrine of secondary meaning to generic terms. The last argument they made is that a top-level domain is essentially a functional feature because it directs the user where to go. And functional features under the Lanham Act are not protectable. Booking.com made some arguments in its opposition to the petition, and their arguments were basically directed towards burdens of proof, but they want to rely on the primary significance test, which is essentially what the Teflon survey was designed to show. So the real question is going to be whether the Supreme Court thinks that these types of Teflon surveys can show a mark is not generic under these circumstances. So hopefully we'll get a decision on this later this year, and we'll see where it goes. So now Chris Smith is going to talk about a case.
Thank you, Rebecca. My name is Christopher Smith. I'm an IP litigation partner here at Brooks Kushman. And in the interest of time, we're going to discuss the American Axle and Manufacturing versus Neapco decision. An interesting decision that came down last fall regarding Section 101. And a little procedural background first. So the case originated in the District of Delaware, Chief Judge Stark, and American Axle asserted the 911 patent against Neapco, and one of Neapco's defenses was that it was invalid under Section 101. Neapco moved for summary judgment on that theory and was granted summary judgment, and that ruling was appealed to the Federal Circuit, and that is the focus of the decision that we're talking about today. So first, before we get into the specifics of the legal aspects of this, I want to talk a little bit about the patent that was at issue. U.S. Patent Number 774911. and it was directed towards methods for manufacturing shaft assemblies for driveline systems for automobiles. And going to the bottom bullet here first, the kind of limitation that was at issue in this case, or the primary focus of the analysis, is this limitation that talks about tuning at least one liner to attenuate or reduce two different types of vibration transmitted through this shaft member that would be part of this driveline system. And the patent, in discussing this tuning concept, talked about the different types of vibrations that could be introduced in a driveline system, such as bending vibration, torsion vibration, and shell forces. And it also talked about different techniques that could be used to attenuate such vibrations, such as the use of weights, liners, or dampers. Claims here focused on the use of liners, and in the district court level, there was actually a claim construction introduced for this tuning concept, which was controlling a mass and stiffness of at least one liner to configure the liner to match the relevant frequency or frequencies. And that was the claim construction that was obviously discussed in the district court, and it was the claim construction that was discussed on appeal. Moving on. So when the Federal Circuit did its analysis, it focused primarily on independent claims 1 and 2 as representative claims. It didn't focus on dependent claims at all. There's definitely a dispute in the case as it goes up on bonk and et cetera about whether or not that was correct. And you'll see the dissenting opinion also takes issue with this with respect to the dependent claims and one analysis and information they add to this one-on-one analysis. But Claim 1 and Claim 22 is what the Federal Circuit, the majority opinion, looked at. And so here's an example of Claim 1. As you can see in red here, the tuning limitation we talked about earlier. And then you go down to the subsequent bullet, and it talks about further talks about this tuning concept with a liner, and specifically positioning the liner in such a way that it's configured to damp these two different types of vibrations, the shell mode vibrations and the bending mode vibrations. And you see on the side here, there's a figure 4 from the patent, and that's an example of one of these drive shafts. And in yellow are examples from the patent of what a liner would look like that would be put in the drive shaft, and then that could be manipulated with different weights, stiffnesses, and things, and the positioning of those liners within that shaft to affect this attenuation of these different types of vibrations, which was the focus of the claims. Moving along. So, again, it's a one-on-one issue. It was a one-on-one analysis, one-on-one argument. And so the Federal Circuit, of course, and I put on this slide, it purports to follow Allison Mayo, because as you're going to see, it's an interesting interpretation in the majority opinion, and the dissenting opinion takes great issue with it. But just to refresh our recollection, so under the Alice Mayo two-step analysis, step 1, you're going to first ask whether these claims are directed to a law of nature, natural phenomenon, or abstract idea. And in this case, you'll see the focus of these claims were whether or not they were directed to a law of nature. And then if those claims are so directed, in this case, in this example, a law of nature, then you have to ask yourself this idea of, is there an inventive concept in addition to that law of nature that's significant in practice amounts specifically more than a patent upon this actual law of nature itself. So moving along here to the step 1 analysis. So ultimately, the conclusion by both the district court and the Federal Circuit sort of agreed was that this concept of selecting frequencies and dampening using these liners was nothing more than an application of Hooke's law, a natural law. Now, within the language of this decision, the court is sloppy, arguably, in how it discusses this, because it talks about Hooke's law, and then it has some addended statement about and other natural laws. And it never talks about, again, what those natural laws could be, or really explains, frankly, what those natural laws would be and how they'd apply to the claims. But the court talks about, in concluding that Hooke's law applies, it says that the claims simply state a natural law, and they do not describe a specific method for applying Hooke's law. I'm going to back up real quick, just to make the point that, so this claim here is written, the court concludes, just applies this natural Hooke's law. But as you see, there's discussion of these tuning liners, there's a discussion of positioning them, and again, the dependent claims become very relevant as well, because they talk about materials used, they talk about different aspects of that tuning. And so the idea that there's no method whatsoever described or nothing whatsoever disclosed seems a little bit of an extreme position that seems to go beyond just Hooke's law, and that's currently part of what's being disputed at the Federal Circuit today. So going back to step 1 analysis, Another part that the dissent really locks onto is the Federal Circuit in this main decision really latches onto this idea that the claims are claiming a natural law and they don't describe how to implement the concept. And there's obviously a debate about whether they do describe how to implement the concept. But regardless of that actual debate, it does bring you into this question of, does 101 require this how analysis to apply or to be applicable? Is it really part of it? And certainly this dissent has its position on that, which we'll discuss shortly. So moving to the step 2 analysis, this inventive concept analysis. So American Axle's primary argument, or a main argument, was that this concept of using a liner to damp 2 different vibration modes had never been done before. And it even goes a step further, and the dissent points this out. This idea of using a liner to dampen a bending mode vibration had never been done in the art before. And so this was he used a strong argument for inventive concept. Additionally, as I said, there were many dependent claims that added to this. But again, the Federal Circuit effectively looked only at the independent claims and kind of disregarded the dependent claims in this context, which is interesting because beyond the fact that the dependent claims are there and they certainly add content, the independent claims by virtue of claim differentiation include what's in the dependent claims, among other things. So it's interesting that the Federal Circuit kind of failed to even look at that. And the court ultimately states, these claims advance is simply controlling various known characteristics of the liner so as to achieve attenuation of 2 vibration modes simultaneously. So again, the Federal Circuit is kind of falling on that this is just a law. You just effectuate this with the changing of the characteristics of the liner per the law, and you attenuate the vibrations. So moving on to the dissenting opinion, up front, this is one of the strongestly worded dissenting opinions I've read, and Judge Moore makes a lot of good points. She first, on the step 1 part of this equation, she points out that it's interesting that the court really doesn't articulate it very well what this law of nature is. And I know in the en banc petition, the point's raised that how can we really have a law of nature if the courts can't even really articulate what it is? And how can we invalidate something on section 1 or step 1 if the court can't even do a sufficient job of really articulating it? But then Judge Moore goes on to say, I'm deeply troubled by the majority's disregard for the second part of the analysis, this inventive concept part, and its fact-finding on appeal, and its repeated misrepresentation of the record in each instance to the patentee's detriment. And again, this is getting to these dependent claim issues and what have you that the Federal Circuit disregarded. So first, the inventive concept issue. I'm not going to belabor this, but again, Judge Moore lists several in these bullets in this top argument, these different inventive concepts that she sees in these claims, some of which are in the independent claims regarding reducing bending mode vibrations, some which fall into the dependent claims, which the court consider. But this again appears to go beyond just a natural law, which is what the Federal Circuit ultimately concluded here. And she specifically raises the point about this idea that the argument that liners were never before used to attenuate bending mode vibrations was AIM's first and one of its strongest non-conventionality arguments. And she points out the fact that Neapco acknowledged this concept hadn't really been done before. And so again, it seems interesting to argue that there's no inventive concept here when even the other side seems to concede that there's one. Now, the last part of this that I think is going to probably get a lot of discussion and is probably going to get a lot of discussion going forward is this concept that, as I said before, the Federal Circuit seemed to really make a big deal about the claims, and again, specifically the claims, not explaining how to implement something, which seems to be a new concept to 101. And what Judge Moore says, this isn't about 101. This how issue isn't about 101. It's about enablement. Whether the claims are enabled is about this how. And so the standard for this enablement, to be enabling the specification of a patent, must teach those skilled in the art how to make and use the full scope of the claimed invention without undue experimentation. It's about the spec, though. Enablement's about the spec being enabled. So now they've made this enablement, in theory, what the Federal Circuit's doing is shifting this enablement requirement from the spec to the claims, arguably, in the context or the guise of 101, which is what Judge Moore's concern is. And so, to conclude here, and like I said, as I said before, this is a strongly worded dissent. According to the majority, it's not enough that a skilled artisan reading the specification will know how to tune a liner to the frequency of any given process. The claims themselves must recite these steps, which would be new law in enablement and certainly new for 101. And just to go to the bottom here, the way that this dissenting opinion ended, I thought was very strong. she first says that the hydro has grown another head, effectively saying that the majority opinion is basically made new law in 101 and has expanded this monstrosity even further. And she ends it with, the majority worries about result-oriented claiming. I am worried about result-oriented judicial action. I dissent. And I think that kind of sums up, and if you read the opinion and look at the dissent in this one, it's very enlightening, and it explains it very well, and it's strongly worded. So with that, I'm going to pass the baton back to Rebecca.
So I'm going to talk about another case that came up in the context of trademarks, but is really a little bit broader than that, and it has to do with what happens to license agreements under Chapter 11 bankruptcy. So what happened, and this is just a summary slide, which you can go back and read. I'm just going to jump right into the case. What happened was that Tempnology was the owner of trademarks for CoolCore. It granted a non-exclusive worldwide license to Mission Product to use the CoolCore marks. Shortly before, about 8 months before the non-exclusive license expired, Tempnology filed a petition for Chapter 11 bankruptcy reorganization. Under Chapter 11, Mission Products had two choices with respect to what to do with this license agreement. It could decide to reject the license, or it could continue to abide by the license. These are options that are available for any executory contract under Chapter 11 bankruptcy law. And for anyone who's not familiar, an executory contract is any contract where the parties are still performing obligations. So once Tempnology decided to reject the contract, Mission Product tried to retain its IP rights under the contract. And this is where the bankruptcy code gets a little bit it's complicated in a lot of ways, but this is a particularly complicated section of it, 365, because 365 has two sections that would seem to compete with each other. On the one hand, there's a provision of 365 that says that if a debtor rejects a contract during a Chapter 11 reorganization, that debtor is considered to be in breach of the contract. Now, outside of bankruptcy law, if you have a license agreement and the licensor breaches, the licensee can either treat the contract as completely terminated and sue for damages, or it can continue to use the IP right that's been licensed. So there's another section, however, of 365 in Chapter 11, which specifically relates to some IP, which says that when an IP contract is rejected, the licensee can continue to use the IP. The problem is, intellectual property in Chapter 11 does not include trademarks. It includes patents and trade secrets, copyrights, works made for hire, but it does not include trademarks. So what Tempnology tried to say is the bankruptcy code specifically provides for when the licensee can continue to use the trademark, and it's only for these types of intellectual property, but not for trademarks. Mission Products, on the other hand, said this should be considered under the other part of 365, which simply says that they rejected it, it's a breach, and we get all of the normal remedies we would get under a breaching situation, which includes being able to continue using the mark. So the bankruptcy court initially agreed with Tempnology and issued an order saying that the contract was essentially no longer in force and Mission Product could not use the trademark. The bankruptcy appellate panel for the First Circuit reversed, saying that while there is this section about intellectual property, it doesn't matter because it's still a breach and we should follow the normal rules for breach of contract. And this is, by the way, the position that the Seventh Circuit has taken, which is that any rejection of a contract is a breach, and then you just go into normal contract law procedures. The First Circuit reversed the bankruptcy appellate panel and went back to essentially what the bankruptcy court said, and basically started with the idea that 365N only covers certain types of intellectual property. It doesn't cover trademarks, so the licensee no longer had a right to use the marks. So Mission Product appealed to the Supreme Court. The court accepted the case to resolve the circuit split between the Seventh Circuit and the First Circuit. And essentially what the Supreme Court held in an 8-1 decision that Justice Kagan wrote was that, yes, there are these other exceptions in Section 365 of Chapter 11. But when you look at those exceptions, they were added for specific reasons. And it was because Congress was trying to overturn a court decision that it did not like. So with respect to the specific provision that was at issue, 365N, which specifically applies to intellectual property, it came about after a case in the 1980s where a judge held that a patent licensee could not continue to practice the patent after the contract was rejected in bankruptcy. The fact that trademarks weren't included shouldn't really be seen as anything more than a reflection of the fact that trademarks weren't at issue in that case. And the Supreme Court said, at the end of the day, trademark licenses are no different than any other contract. And under the bankruptcy code, when a contract is rejected, it's considered that the debtor is breached, and the non-breaching party has all of the remedies that it would normally have. And in terms of a trademark license, that means that the licensee can continue to use the mark if they so choose. I will say it's an 8-1 decision, but there wasn't a dissent on the substantive issue. The dissent was from Justice Gorsuch, and it was about whether the court really had jurisdiction, whether there was an active case or controversy. Here, on the slide we have some consequences of the case. I think the big one is it's any executory contract. The other thing that I think is important to note, just because it came up in all the levels of the case, is that under a trademark license, the trademark owner has a duty to police the use of its mark, or it can be accused of naked licensing and use its rights. So a debtor who's in bankruptcy needs to make sure it knows what is happening with each of its licensees so that it does properly police the use of its mark and that its mark will survive through the bankruptcy. And now I'm going to turn it over to John to talk about our last case.
Thanks, Rebecca. This is going to be the lightning round. We're not going to hold anybody after the bell or keep anybody on detention here. But we're going to talk about an appeal that came out of the Patent Office pertaining to IPR petitions, and specifically whether administrative patent judges, APJs, are constitutional or not. The Arthrex v. Smith and Nephew case, the technology in the case relates to a medical tool for tying knotless sutures. Smith and Nephew petitioned for IPR. They did not petition all claims, but of all the challenged claims, the PTAB found them anticipated, and Arthrex appealed to the Federal Circuit. Whoever said you should only make 1 or 2 arguments to the Federal Circuit should reconsider, because here, Arthrex made 5 arguments. Federal Circuit overlooked the first 4 and picked the last one, the constitutional argument, which began on page 59 of the appellate brief. And the Federal Circuit paid no attention to the more substantive patent issues, such as incorporation by reference, new matter, and some of the other interesting arguments raised on appeal. But jumping into the constitutional argument, Judge Moore raised 3 questions. First one, procedural. This constitutional challenge was raised by Arthrex for the very first time on appeal. It was not raised before the PTAB, so the question is, was there a waiver? If there was no waiver, jumping into the constitutional question, are APJs what the Appointments Clause of the Constitution considers principal officers or inferior officers? We will quickly learn here that principal officers must be appointed by the President of the United States and confirmed by the Senate. Inferior officers need not be. We all know that APJs are not appointed by the President, so if they are principal officers, in view of what they do each day, there's a constitutional defect. And if there is a constitutional defect, what should we do about it? So I'm going to short-circuit this. Basically, the Federal Circuit said it would have been fruitless to raise this constitutional issue in front of the panel of APJs challenging their authority to be sitting there. But even beyond futility, this is a pretty important issue, and the Federal Circuit has discretion to sidestep waiver issues, and this is an instance in which the Federal Circuit decided to do so. Jumping into the actual Appointments Clause, I'm not going to read it to you, but as I indicated earlier, it creates sort of 2 classes of officers of the United States, the principal and the inferior the former requiring presidential appointment, because it's at the end of the day political, and these officers have to be accountable to who the public elected into office, and we want to avoid the president and Congress sort of willy-nilly dispensing power. So we got to jump into the meat and potatoes, principal versus inferior. There was very little doubt that these were in fact officers of the United States, so they fell within the scope of the Appointments Clause. The question is, do they exercise significant authority pursuant to the laws? Clearly they do. They effectively hold trial, discovery, all the sorts of things we see in the federal courts, we see in the PTAB proceedings, and of course the PTAB itself describes these as trial-like reviews. So we're clearly in the Appointments Clause. It turns out that in the late 90s, the Supreme Court had set forth 3 factors to consider. It's a factor-based analysis. These are not exclusive, but these are 3 things to consider in determining whether a particular officer is a principal or inferior officer. So we had 3 things to look at. So slide 48 has a chart where all I've done on the left here is laid out the factor, and on the right, how the Federal Circuit came out. In terms of whether an appointed, in this case, the director is the appointed official, the director or the Secretary of Commerce, I suppose. They are the appointed official, and so does the director have the power to review and reverse the officer's decision, in this case, the administrative patent judge? The answer, of course, is no. The director has no power to independently review or reverse a PTAB final decision. At most, even if the director sat on a panel, he is one of 3, and so he can get outvoted, and nobody's going to suggest that he would control the other 2 votes. He could do some other things, which I've enumerated here, but at the end of the day, he cannot review or reverse a PTAB decision. In terms of the second factor, the director does exercise substantial supervision and oversight over the Patent Office, including the APJs, with their precedential opinions and their policy directives. And so this one, the Federal Circuit held, would weigh toward the APJs being inferior officers, not requiring presidential appointment. But the scale is tipped to number 3. Can the director of the Patent Office, for any reason he or she so chooses, remove an APJ? And the answer is no. The Patent Act integrates Title V's language on for-cause termination. And because APJs can only be removed for cause, the director does not have the unfettered power to remove them at his or her discretion. So it's sort of 2 to 1. So we know that APJs are principal officers according to the Federal Circuit. And then the question is, what are we going to do about it? There were a couple remedies that were proposed that were rejected. By the way, my bullet where it says sever the Section 3C 3-member panel requirement in its entirety, that was rejected, but that's actually supposed to be 6C. That's a typo. The second main bullet is the remedy that everybody agreed to. They didn't all agree there was a constitutional violation, but if there was, they agreed that one solution would be just to sever that portion of the Patent Act that applies Title V, the for-cause termination, which then makes APJs subject to at-will termination at the discretion of the director or the president or anybody else. Thus, 2 of the 3 admin factors support inferior officer status, no presidential appointment is required, and we can go about our business. There's precedent for it. They were not plowing new ground here. They're just applying prior decisions. And in terms of the output, in that case, they remanded the IPR to a new panel, but the new panel had the decision to just operate on the existing record, take new briefing, or reopen the record if they needed to, but they did not have to start from scratch. And the Federal Circuit was very clear that this decision applies only to appeals of final decisions in which this issue is raised. The takeaway, a couple takeaways. Number 1, if you have a pending IPR, you should raise this below. Just because Arthrex got around the waiver issue, don't rely on that. Raise the issue and raise it often and avoid the waiver issue. But secondly, and perhaps more importantly, this isn't going to move the needle a whole lot, because either these are principal officers or they're inferior officers. If they're principal, we're going to modify the statute. It's not really the end of the world, and the sky's not falling. I don't see any instance in which the Federal Circuit on en banc review or the Supreme Court is going to tip over inter partes review anytime soon. But we will be hearing about this case again because all three parties, well, the two parties and the government intervener are unanimous in seeking en banc review. I expect we are going to get it. I don't know if it'll be affirmed or not, but at the end of the day, IPRs are going to continue to exist. So I think we are at the 1 hour mark. I want to thank everyone for following along, especially in the lightning round. These slides and our emails are available at our firm's media center online. Feel free to contact Chris, Rebecca, or myself with any questions. You can telephone us or shoot us an email, and we look forward to hosting another webinar for you soon. Thank you very much.